Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you will enjoy this legal education content, and today might be the day I earn your subscription. For today's live stream, we are doing the story of the Critical K. The Critical K has been sued by the mother of a person whose child, or the mother of a child who's deceased. That's the best way to put it. So Critical K has been sued by a mother whose child is deceased. There you go. And they're alleging defamation of the mother, that she has done a bunch of things, and the mother is saying these aren't true things. Okay, there you go. So the Critical K, Cray, has filed her answer. And this is kind of interesting because it is very typical, although it doesn't happen every time, but more often than not, in fact, quite a bit more often than not, that you'll first get a motion to dismiss. You'll bring up the motion to dismiss on the technical aspects. In a motion to dismiss, as we all know, because we've covered it many times, you assume, by law, that everything the other side says is true. The premise is, even if everything they say is true, I still win, so what's the point of having a trial? Because it doesn't matter. If they win on every single element they allege, I still win as a matter of law. So you assume everything the other side says is true. We've discussed this before. But if you want to say, well, I don't want you to assume everything is true, I want to actually contest the facts. At that point, you're addressing the merits. And you can't do that except in an answer. And that's exactly what we've done. So now we want to say, not so much that we think we'll assume your facts, but we also want to contest your facts. Okay, so we're skipping the whole motion to dismiss. This was the thing in the Without a Crystal Ball, Toddy Without a Crystal Ball, that we spent like 40 different documents on, right? It was all one big motion to dismiss that lasted forever, right? So we are skipping that entire step. We never even got to the answer in Without a Crystal Ball because the motion to dismiss was successful, right? We never even got to that stage of the case. So we basically skipped from step 1 to step 3. We bypassed step 2 completely. Okay, that's fine. We can do that. So we're going to read this and, consider it for its merits and see how it goes. Water is tasty. Let's start reading. So we're also going to try to move to dismiss at the same time, which I suppose is something we can definitely do. So we'll do that. Whether or not this court has jurisdiction is a matter of law. However, the defendant asked the complaint to be dismissed on lack of personal jurisdiction. We'll see if we spend any time on that argument. Dismiss the action on the grounds it's frivolous, vexatious. I don't actually know this word. What is this word? Meretricious? I don't know this word. I have to look this one up. Hold on. A new word in my vocabulary. What is this word and how is it pronounced?
Meretricious.
Meretricious. Meretricious. Okay, this is fun. There's two definitions in the dictionary. There is an archaic definition, which the old definition that's fallen out of use, meretricious, apparently used to mean relating to or characteristic of a prostitute. That's kind of hilarious. The more modern definition is apparently attractive, but having in reality no value or integrity. Yeah, okay, that's a new one. We have gained a vocab word for the day. All right, fine. And utterly without merit, which is kind of implied by frivolous and vexatious, but okay. In line with several other cases that have been brought by the plaintiff against a variety of defendants, merely to harass the defendants as part of pattern behavior that have been established by the plaintiff to bully, cajole, threaten, and ruin the reputation and or finances of all those who she perceives to be enemies, opposed to her agenda to deny the official determination of self-harm in the tragic death of her son, Christian Andiachero, by self-inflicted gunshot wound. Yeah, so the mother isn't buying this. And there's apparently some evidence that might suggest that it may not be true, but that's what the mother thinks. The mother doesn't think the self-harm. Okay. The defendant submits that by virtue of her deliberate and relentless public actions, Christian Andiachera, the plaintiff, has established herself as a public figure who cannot be defamed in absence of malice. We need to know a little bit more than we know so far to reach that conclusion. She has been from what my understanding is, the mother here who is suing has been a very passionate advocate for the fact that her son did not harm himself and calling on the various people to review the case. Does it quite make her a public figure? And debatable. It's debatable. I don't know. So we could get into that. The defendant hereby refutes allegation or complaint that she had any malice towards the plaintiff prior to statements that are made subject to the complaint. I think we're misusing the word malice here. Okay, we're definitely misusing the word malice. So I skipped over part of 5, right? The defendant submits that by these public statements, she cannot be defamed in the absence of malice. That's true. But then she says the defendant hereby refutes the allegation in the complaint that she had held any actual malice towards the plaintiff. That's a mistake. That's a mistake. When we say malice in defamation law, it's a term of art. It has a meaning in defamation law that is not what you expect. So it is incorrect to say, well, I didn't have any malice to her mother, or I didn't have any malice to Christian. That's wrong. Legally, it's wrong. That's not the right standard. The right standard, if you want to go to what malice means, and actual malice, you want to see actual knowledge that what you're saying is false, or reckless disregard that what you're saying is false. So you actually know, or reckless, which is a higher standard than negligence, recklessly disregarding. So, as I've often said, it's not malice to the person, right? We don't care whether we really don't care either way, whether she has malicious thoughts towards the mother or towards the dead child. We don't care either way legally, because that's not the right standard. The right standard is, does she have malice to the truth? And you can show that by showing that she actually knew, which means she has malice to the truth because she's lying, or recklessly disregard. She purposely blinded herself so she wouldn't learn the truth. That would be malice to the truth. So that's an incorrect statement of the law. So, yeah. The defendant has never met or spoken with the plaintiff on any occasion prior to statements about plaintiff that are subject to this complaint, and has no cause to feel maliciousness towards her. Legal fail. Legal fail. Defendant merely repeated public allegations made by others against the plaintiff, who have been irrefutably evidenced and documented in the public domain by victims of plaintiff's pattern of bullying, cajoling, threatening, harassing, and abuse, which includes a wide assortment of people: private citizens, the public, members of the Justice Department, and officials of the city. So, specifically, particularly on government documents, you can rely on those because they're government documents. So, and what other people are saying, if, you can, as long as you're not doing it negligently, or recklessly in this case, or negligently if she's not a public figure, which would be the alternative, then you need to show that, she had sufficient information to the contrary, that in the case of negligence, she should have followed up, or so much alternative information it was completely ignorant to ignore it, right? In the case of recklessness, you're not looking for like one piece of evidence or like two pieces of evidence. You're looking for something that's either of sufficient number or sufficient quality that would cause a person not merely to say, maybe I should pay attention to that, but hey, this seems really wrong. Maybe I should dig deeper, right? You're looking for that kind of thing. Far from being reckless as to the facts of the situation, that's close to correct. The defendant merely repeated well-established facts of the situation with irrefutably evidenced and documented. Well, I'm not sure about irrefutably because the mother is refuting them, but whatever. The plaintiff, through a relentless and willful pattern of bullying, cajoling, threatening, harassing, and abusing others, we're very proud of this phraseology, so we want to say it many times. Okay. Both directly and through the incitement of third parties to bully, cajole, threaten, harass, and abuse her aforesaid perceived enemies. Her enemies would have been fine. Aforesaid is too sophisticated by half or something. Has established a public reputation as a bad actor that has not been materially affected by any statements made by the defendant that are subject to the complaint. So we're trying to maybe go for some idea that she's defame proof. That's hard to do, but if that's the idea we're going for, then okay. The defendants merely repeat public observations and assertions of others that are fully documented in the public domain. Okay. Defendant refutes that she has caused the plaintiff any emotional damage that had not already been caused by plaintiff inflicting said damage on herself as a result of the consequences of her own statement. So you're attacking causality? I mean, So you're saying, well, I said things, but I don't think they caused the problem. Those things were caused by other things. I mean, that's a perfectly valid defense. The commission of a tort of invasion of privacy necessarily requires negligence on the part of the defendant. The defendant asserts she's not been negligent in regard to any alleged damage to the defendant, but rather sought the pursuance of the benefit of public at large and the public interest in reporting accurately on facts pertaining to the public statements and actions that be irrefutably evidenced and documented. Again, I'm not sure that they necessarily fall into the category of irrefutably, nor is that legally required, right? As I was saying, right? It doesn't have to be irrefutable. And if there's things that refute it, that doesn't necessarily make you negligent. It doesn't necessarily make you reckless, right? It would be negligent if it looks like, okay, maybe I should investigate this piece of information because this piece of information is a little inconsistent. So maybe I should look into that, right? But if it's so so trivial that you're like, or it doesn't make sense or contradicts or so blatantly obvious to you that's like, I'm going to ignore that. You can do that. And then recklessness is not that, it's kind of a little bit maybe suggestive. It's more, it blatantly contradicts the case, and I should, look into that a little bit more as I'm trying to determine what the truth of the situation is. Or at a bare minimum, I should acknowledge in my reporting that there is significant evidence to the contrary, because then I'm giving you all the facts, right? Defamation only applies to facts, not opinion. So if I, in my paper, say, here's a whole bunch of evidence that supports a conclusion, here's some evidence that supports the contrary conclusion, my opinion is the first evidence is more probable, right? I've given you all the information. I've acknowledged it and put the person on notice of what it is so they can form an independent basis and then give them my opinion. That's how you normally do this. The complaint alleges defendant has accused her of bullying. Defendant hereby asserts the plaintiff has established a clearly defined pattern of bullying of others in most egregious manner, as fully evidenced and documented in the public domain. The complaint alleges defendant has accused her of intimidating or accepting to intimidate others. The defendant asserts that the plaintiff has established a clearly defined pattern of attempts to intimidate others in a most egregious manner. I don't really like the extra superlative. Egregious would just be fine. Most egregious? Yeah. It's, again, too clever by half. As fully evidenced and documented in the public domain. The complaint alleges defendant accused her of lying. The defendant hereby asserts the plaintiff has lied in official statements, as fully evidenced and documented in the public domain, not the least by members of the Justice Department. Well, whether or not the plaintiff has lied is kind of immaterial to whether or not you have lied. So, sure, the plaintiff is a liar. Let's accept the premise. The question would be, did you lie? Which can be assessed on its own terms. It might weaken the plaintiff's credibility, but we can still assess it onto its own merits, right? The complaint alleges defendant has accused her of bullying. Oh, we read that. Okay. The defendant asserts plaintiff's wish to bribe and get a minor drunk in order to further her ill-advised agenda is fully evidenced and documented in the public domain. You know, I don't really like this because there are no footnotes, and I don't think there's any attachment. No, it's only 3 pages long. This is only a 3-page long answer. This is kind of weak sauce. This is a weak sauce. Because you're not saying here is the things from the public domain. What are you expecting? The court to go look? That's not how that works. Right? Let me explain this. Let me explain to you how it works. Okay? What you do, you see, is each side presents evidence to the court. Right? And the court looks at the evidence that has been submitted and accepted pursuant to rules of evidence. And then the court/jury, as the case may be, evaluates the evidence and comes to a conclusion. What you can't do is simply say, oh, it's in the public domain. The public domain is not part of the record. It's not like submitted to the court. You can't just say, oh, there's so many things in the public domain. What things? So many things. Like what? The many, many things. Would you like to give us an example? So many. You know, that doesn't really work. So, ideally, what you'd want to do here is you'd want to provide some attachments and say, here is some examples. It doesn't have to be like a lot. You know, if you could find maybe 3, that would be great because, 2 or 3 sources is nice. So you could provide like 2 or 3 sources that show this or government documents that show it and attach it. See Exhibit A, see Exhibit B, see Exhibit C. Right? Oh, they're just in the public domain. If you come to me as a judge, it's like, what the hell am I supposed to do this? What do you expect me to do? Go onto the internet and do searching? That's not what I do. What I do, once again, is consider the evidence submitted. And you just say, oh, there's evidence out there. Somewhere out there beneath the gray moonlight. You're guilty. No. Yes. Yeah. The complaint asserts the defendant insinuated that the death of Hayes Michael from a drug overdose was the result of medical malpractice on behalf of the plaintiff in her capacity as a nurse practitioner practicing in the mental field. Defendant has made no such insinuation. The plaintiff has been subject of numerous complaints for breaching plaintiff confidentiality. She has also breached plaintiff confidentiality in the case of Hayes Michael by divulging that is not a proper sentence. I'm not misreading it. It's just not proper grammar. Okay, I'm just going to read this as written and we'll have to press on. She also breached patient confidentiality in the case of Hayes Michael by divulging what she alleged Hayes Michael told her, okay, I guess it was proper, while under her treatment and care. Yeah, okay, I retract my previous statement. It was grammatically proper, and I just had a parsing fail. That's my bad. The plaintiff therefore grossly mistreated and harassed Hayes Michael and several other of her patients by breaching their right of patient confidentiality and with the most egregious. Wasn't it O.J. Simpson who said, I'm 100% not guilty? Not guilty would have been fine. I'm 100% not guilty. It's like overcompensation, thinking you might be a little bit guilty on that one. It's most egregious. It's not just egregious, it's most egregious. Please tell me the difference between egregious and most egregious. I'm not sure I know. In the case of Hayes Michael, the plaintiff has even litigated against his estate after his tragic death on the basis of the breach of confidentiality. Okay. Mitchell, not Michael. Mitchell. You're right, Mitchell. I apologize. Mitchell, thank you for the correction. The public may draw whatever conclusions it deems appropriate from the plaintiff's established pattern of abusing the right of patients and from her broader pattern of abusing, bullying, harassing those she deems to be enemies. Once again, would you like to provide any evidence of all of this broader pattern? Would you like to provide examples of this broader pattern? You said that she's brought lots of lawsuits. Would you like to maybe cite to them? Would you like to cite language from the courts that have considered them and said, perhaps, this is crap. This is totally BS. Assuming the courts actually said a thing. Would you like to provide examples where courts have been like, what the hell are you doing? This doesn't make any sense. Would you like to provide examples of her harassing and bullying and all the rest of it? Anything. Tweets, Facebook posts, statements on the news, statements to TV, statements in print, statements made before an audience somewhere, anything at all. Would you like to provide any kind of evidence? No, you wouldn't? I'm not sure what you want me as a judge to do about this. No. No. She wrote this herself. I definitely believe that. Defendant explicitly hereby denies that she stated or insinuated the plaintiff was responsible for the death of her son. Oh, okay, I'm definitely sold, because you deny it. Indeed, she expressly stated that Christian Andiachera died by his own hand, which is not a false light statement of personal opinion, as alleged by a matter of public record. The defendant asserts that since the death of her son, Christian... What? You're the defendant. No, it's not your son. Oh. No, wait, it is. Okay. Wait. All right. Hold on. Defendant asserts that since the death of her son, Christian Andiachera, the plaintiff has relentlessly and continuously invaded her own privacy by her deliberate public statements and actions. Defendant has not invaded the plaintiff's privacy beyond the scope set out on the plaintiff herself. I'm totally sold. Yeah. Thank you to the new supporter, Life in the Red Cow. I appreciate it. Defendant asserts all the statements she made with regard to the death of Christian Andiachera and its aftermath have been with intent to further the public interest. Once again, we don't care really about your intent. It's not an element of defamation. It's not an element of your intent. I was trying to do good things. I was trying to do right by the world. All right, I just don't care. I don't care. You could actually go completely the other way. I was purposely trying to harm society. I was trying to bring society down. It was my goal and mission in life to bring everyone down, especially these people. I want to make them suffer, and I still wouldn't care legally. I wouldn't care legally. Because that's not what malice means. Again, it's not malice to the person or malice to people. Malice has nothing to do with people in this context. What we mean by malice is, did you actually know what you're saying was false, or did you recklessly disregard what you were saying was false? One of those two things. At no point do we ask, how did you feel about the person? What did you hope for in your wishes and dreams? What did you hope for in society's wishes and dreams? I wanted to make everyone suffer. I wanted to help the world. Either way, I just don't care. Just don't care. That's not what malice means. It has nothing to do with the person. Super wonderful. You're screwing up the law on this one, Karen. The plaintiff claims it's false light for the defendant to claim that her son, Christian Andiachera, died by his own hand, yet is such the official verdict as to his death. I don't think verdict is actually the correct word here. I'm doubtful. I'm not sure that what the medical examiner or the coroner says can legally be thought of as a verdict. So, yeah. The defendant has not shown a false light on this or any other aspect of the situation, which is the subject of this complaint. She has merely repeated what has been fully evidenced and documented in the public domain. Again, would you like to provide some evidence of that? Would you like to submit some things from the public domain? Some governmental records, newspaper articles, quotes from podcasts, tweets, Facebook posts? Would you like to show what the public record is? The things that you say you were relying on, would you like to provide that? No? You wouldn't? So as the judge, what exactly are you expecting me to do here? How am I supposed to judge the non-existent evidence? Okay. The defendant asserts all statements have been made with regard as aftermath have been with intent. Yeah, we don't care. For any other allegation made in the complaint by plaintiff that have not been explicitly addressed in this answer, defendant hereby expressly refuses such allegations and asserts she's not materially defamed the plaintiff in any way, nor has she invaded the plaintiff's privacy beyond the requirements to serve the public interest. That's not the standard when it comes to invasion of privacy. Again, whether or not you're trying to serve the private public interest or not has basically F all to do with whether or not it's an invasion of privacy. The law simply does not care. Request for video recordings of the proceedings. Yes, I would like video recordings because this sounds hilarious. That'd be great. And I'm sure that the plaintiff's attorney will be more than happy to videotape the depositions. More than happy. Yeah, I don't see that being a problem. Now, actually videoing the court proceedings might be another factor, but somehow I'm not imagining we'll get that far in the end. But, that's another problem for another day. Not that you need necessarily a video recording, because you do have a transcript, right? So, yeah. As the plaintiff has a well-established record of misrepresentation of facts related to official proceedings, processes, and proceedings, the defendant hereby requests the court allow that any proceeding in a court of law be allowed to be video recorded on behalf by defendant. Yeah. While there may or may not be a written transcript made available of such proceedings, there are. Such written transcript will not carry the weight of a video recording to be made available in the public domain. I am very sure that plaintiff's attorney will have no objection to videotaping your deposition. And if you want the public to be able to see this deposition, I'm just simply saying, I'd be more than happy to get a copy and review it. Because given how this response is going, or this answer to be slightly more proper, that might be hilarious. Respectfully submitted this XX day, and she doesn't even bother to correct the typing. She doesn't bother to actually go in and correct XX to be 23. She just writes on top of it. That's nice. Of June of 2021 to the clerk of the United States District Court for the Southern District of Mississippi and to the plaintiff's official representative at whatever P.O. Box signed, Karen Yaks. Well, that was extremely disappointing from a legal level. That was a massive, massive disappointment from a legal level. This is just bad. It's horrible. It's horrible. Apparently, there's also a motion to compel. Let me find that thing and see what that is, because that might be fun, since we burned out on covering this thing. So let me download the motion to compel and see what that is, because that might be fun. Hold on. This is just really disappointing. It screws up the legal standard for defamation. It is not formatted like a lawyer would write it in any possible respect. It just says there are things in the public record without providing any of them. The court is definitely not going to go look. There's some problems. I seem to recall on the prior live stream when we covered the complaints that the chat was telling me their critical K has receipts, and she definitely has receipts. And I said, great. I look forward to the response. Where will we get these receipts? She has them all. And someone asked, is truth a defense? I say yes. Truth is an absolute defense to defamation. It's an absolute defense. One of the elements of defamation is it's false. So if it's true, it can't be false. So yeah, truth would be an absolute defense because it nullifies an essential element of the charge. And people are saying, oh, she has receipts. She gets receipts for everything. She has receipts. Did we get any of those receipts? No. No, we did not. It's very, very sad for all of us collectively. Pacer is deciding to take its sweet time, by the way, in case you're wondering why I'm stalling. Okay, what is this? A main document and a good faith letter. Ooh, that might be fun. All right, let's review these things because that will make this stream more entertaining. I don't want to save it. I want to save it as a PDF. That's what I would like to do. Okay, fine. And then I want to get this letter of good faith because I don't know what that is, and that sounds hilarious. Hold on. I didn't download these in advance because, I thought we'd have more to talk about, but we did not. So, Talk amongst yourselves while I pull this up. She's going down in flames. She is going down in big, big flames. Big flames. So big. So flames. Oh, this is what is this thing? What the hell is this? I'm having way too much fun. No, I don't want to download it as a web page. I want to download it as a PDF, like a normal person. Can I download as a PDF? Apparently I cannot. Why not? All right, fine. We'll do it the hard way. Okay, we're back. We're back. All right, let's continue with some more legal documents and see if they're, provide us anything that we can talk about in a semi-intelligent way. Yeah. Let's do this thing. These are okay. All right. All right, so we have a motion to compel that the plaintiff has labeled urgent and necessitous. Okay. Video or telephone hearing requested. That'll be hilarious. Miss and Stephen Photos donated $5. More flames. Thank you very much. I appreciate it. Yeah. Miss Andia Chera filed her complaint on June the 4th. Summons was issued to Miss Yax that day. The summons directed Miss Yax to serve on plaintiff an answer to attached complaint or motion within 21 days. Okay. On June the 24th, 2021, Miss Yax filed her answer pro se. Although Miss Yax asserts the last personal jurisdiction, she raised no other 12B defense. Moreover, Miss Yax has not filed a separate motion asserting personal jurisdiction as required by the rules. So in the local rules, right? In the local rules, you can't do this as a combined document, right? There's the federal rules of civil procedure, which are augmented by the local rules, which are augmented by the specific judge's rules. You have to read these all, and file accordingly. So you can't, and apparently you can't file a combined answer and motion to dismiss before this particular court. So you have to do them separately. You can do them at the same time, but you have to do them separately. Okay. On July the 12th, this Honorable Court entered its Rule 16 order and set a telephone case management conference. The initial order states, not later than 21 days prior to this, the council shall confer all matters regarding set forth in the local rules. So there's a requirement that before the telephone conference, the attorneys have to talk to each other. And if she's acting as her own attorney, then fine, but they have to interact to discuss things. Okay. This order comports with the rules which require the parties to confer, at least 21 days. All right. As such, the parties, whether represent or pro se, had until August the 6th to confer about matters set before the court. Due to his obligations with other clients as well as personal illness, the undersigned counsel was unable to contact Yax until August the 2nd, which is fine because it's before August the 6th. So it's within the time band. A copy of the undersigned correspondence is attached below. Dear Miss Yax, so this is coming from starkvillalawyer@gmail to the Critical K, whose email apparently is kkdo2@gmail. kkdo2@gmail. Okay. All right. Dear Miss Yax, pursuant to the initial order that was entered, you and I must meet telephonically on or before August the 6th to have a conference. Per the court order, we must confer over phone about topics enumerated in the rule. For your reference, here is the rule. Because he's always talking to a pro se, so, being a little bit helpful there. I'll be out of the office tomorrow morning, but I should be able to visit on Wednesday, Thursday, or Friday. Please let me know what the best time is. I look forward to speaking with you, Matt Wilson. This is a very nice email. Pursuant to the rules, we're required to meet. Here's the rule. Here's when we can meet. Let me know what works for you. This is very professional and very nice. I'd be happy to receive this email from another attorney. Oh my God. Okay. All right. Okay, guys, we have to properly brace ourselves because I read about 3 words of the Critical Case email, and I'm like, oh no, I didn't get very far to be able to read it. So I think we all have to brace ourselves for the email Miss K sent back. Now, I once again want to state for the record very clearly, this was a very nice, professional, even somewhat kind email, right? There's nothing wrong with this email. In fact, you could even say it's exemplary. This is best practices, in my opinion. This email's great. What does Miss K want to say in response to this? All right, guys, let's brace ourselves accordingly. To Matt Wilson, the Mississippi court procedure is irrelevant until there's a ruling that the state of Mississippi has jurisdiction in this matter, a matter where I'm contesting. No. The rules of procedure are relevant at all stages of proceedings. And if you want to contest jurisdiction, that's perfectly fine. There are rules for it. And you have to follow those rules. Okay. In the longer term, I will require you to provide a detailed itemization of what economic damages have been done to your client. Who heard my programs? Who had a positive view of Ray Andichera beforehand and a negative view afterwards? That's not relevant because Ray isn't the one suing. What economic damages have my words done to a psychiatric nurse with an appalling reputation both personally and professionally, a reputation which existed years before I came along? This is not a particularly good way to win friends and influence people. Yeah, it's great. Unless you can answer these questions persuasively, there's no case and no jurisdiction in the state of Mississippi. Yeah. I do not voluntarily enter the Mississippi court process. I challenge Mississippi's court jurisdiction. Kind of, but not really. I mean, you just said I'm challenging it. You just said I'm challenging it. You didn't provide the rule. You didn't provide any legal analysis about specific jurisdiction or general jurisdiction, right? You could go, if you want a good reference for this, by the way, you could just go look at the one Brown filed in his motion to dismiss. There was a lot wrong with that motion to dismiss, as I made very clear in my review. But the legal arguments, as it related to jurisdiction, were actually pretty good. There was 8 pages of completely irrelevant tea, which was bullshit. There was no motion to dismiss the defamation, which was pretty bullshit. Also, Brown forgot to state the rules for some of the motions. That was not great. But the stuff he wrote on jurisdiction was actually pretty good. So you could just pull that and look at it, and you could rewrite some things so that it would apply to you better. Submit that, right? You can cheat from another attorney. And let me tell you, other attorneys do this literally all the time. We absolutely plagiarize the absolute shit out of each other, like all the time. Plagiarism isn't so much a sin in our profession as a collective pastime. You know, when a lawyer has to write something original, they get a little bit frustrated because they want to use what's worked before, right? Well, that worked before. That's worked, so let me just steal that because, well, it worked before, so it worked this time, right? So attorneys steal from the ever-living shit out of each other. So you could just become one of us and plagiarize to your heart's content, but, okay. In addition to all this, okay, I have alerted the court to threat made against my person by Chris Thompson, your client's brother and associate with Justice for Christian Facebook group. Christian Thompson stated she keep on and somebody gonna change her name to critical care or drop her off at the train station, one of the two. Yeah. Your flippant disregard of this and your close and lengthy association with Justice for Christian Facebook group and the administrators are all the reason for me to feel uncomfortable and unsafe having a phone conversation with you at this time. Critical thinking plus civility equals winning. Well, that might be true. It would have been nice had you demonstrated either one of those. But, Okay. That's fine. That evening, the undersigned counsel responded to defense refusal to comply by sending her a good faith letter via email. Right? So, you refused to comply, so we responded by saying, here's a letter to inform you more. Right? We're trying to act in good faith over here, and you have ignored us. Okay. In view of Miss Yak's contention, the procedures of this court are irrelevant. Her feeling unsafe talking to undersigned counsel over the phone. And her refusal to respond to the good faith letter, Miss Yak clearly does not wish to comply with the court's order. Yeah, I think I'm inclined to agree with the attorney for the plaintiff on this one. Seems like that's. Therefore, Miss Andiachera moves this honorable court to order compelling to confer so the conference can be conducted efficiently and without delay. Yeah, no problem. We're going to have chat. We're going to have to chat between the court and Miss Yaks over here. I'm going to have to smack her around a little bit. And she's probably going to get irritated with the court and probably say something foolish and probably wind up in contempt. So, you're not the boss of me. You have no jurisdiction over me. This court sucks. You can't do anything to me. I have this big hammer over here. Watch what I can do with this big hammer. Given the straightforward nature of this motion and simplicity of the relief, they request that they dispense with briefing. Yeah, I'm there. Therefore, the plaintiff prays for entry of an order to compel prays for an order requiring defendant to pay reasonable attorney's fees in pursuit of the motion. Which, yeah, right? You can't normally get attorney's fees, normally. But when it's due to your not complying with the rules and you forcing them to do something they shouldn't have to do, right? They shouldn't have to file a motion to compel, like ever, because you are required to do it. So you can get attorney's fees for this, and so the next logical thing to happen would be an order to show cause from the judge. Or even better, how about a telephone conference where I just whack you over the head a lot? That might be fun. Or maybe both. Okay, yeah, that's great. And we have a certificate of good faith. I certify I made a good faith attempt to contact defendant about this dispute, but the attempt has been unsuccessful. He's required to try. He's required to try, and he did try. So it's like, I followed the rules. Miss K, not so much. And I certified that I gave, the defendant a copy by emailing her, which is, or mailing her as the case is. So, fine. Okay, great. Let's read this good faith motion. Oh, that's cool. I respect this guy automatically more. Look at that. I'm going to have to write this guy because he's admitted in Mississippi, Tennessee, and before the USPTO, which means he's a patent lawyer. Maybe he can give me a job, actually, because I'm kind of tired of the patent law thing. I've been doing it for a long time. So he's a patent lawyer, too. That's what that means. He's admitted before the USPTO. That means he's a patent lawyer. And now he does defamation work. I wonder if his office is hiring. Maybe I can send him a resume, because that sounds like fun. Patent lawyers now doing defamation law. Excellent. I'm in. Let's go. I immediately like this guy more. Brothers in arms. The correspondence is a response to the August 3rd email. Rule 26 of the Federal Rules of Civil Procedure, note, these are federal rules, not Mississippi rules, just to make that clear, states the following. Conference of the parties planning for discovery. Except in a proceeding exempted from initial disclosure under the rules, or where the court orders otherwise, the parties must confer as soon as practicable, in any event, at least 21 days before scheduling conferences to be held or scheduling order is due. Okay. Pursuant to the court's initial order and rule conference has been scheduled. Ergo 21 before these dates is August the 6th, which, was yesterday. Therefore, pursuant to the court's order, we must confer before August the 6th. He's sending this on August the 3rd. He's sending it with 3 days' notice. So, fair enough. He's not sending it at the last minute. So, okay. Phoebe says, you looked at all the videos and none of the titles give me a clue as to which one Ken is on. Who's Ken? Unless you're not referring to my channel. Anyways. With respect, I cannot understand how you're with respect, I cannot see how talking with me over the phone would make you feel unsafe, considering that your residence in Michigan is nearly 900 miles away from my location, Mississippi. Do you really believe I'll reach my hands through the telephone to inflict upon you some sort of physical calamity? If you truly believe that, then I'm sincerely flattered you think so highly of my capabilities. Kiwi Farms? Well, try Kiwi or something. But yeah, I could find it. Okay. But I digress. The reality is you're simply making excuses and silly ones at that. Therefore, in good faith, I'm giving you one more chance. One more chance to give me a day and time this week when we can discuss the boundaries of discoveries. Wednesday, Thursday, or Friday, good. I'm free all 3 days. If you refuse to cooperate with my request, I simply prepare the scheduling order to the advantage of my client and submit the same to the court. Then when we chat with the judge on August the 27th, you can explain how your irrational fear of me and telephones was a valid cause to disregard. I will also file an appropriate motion alerting the court to how you believe the rules are irrelevant. We are not playing games, Miss Yaks. Govern yourself accordingly. Sincerely, Matt Wilson, patent attorney at law. Patent attorney at law. I want to look up his reg number because I can. See if he's bluffing. Hold on. Let's find also if my number is earlier than his, so I can feel slightly more superior. All right, so let's look up his name. Wilson, and his first name is Metz, which, whatever. Okay, search for all that. Okay, yeah, well, Mississippi at least. And that's the address that's the guy. What's his reg number? 67,000. I beat him by 10,000, man. I beat him by 10,000. Yeah, his registration number is 67,000 something. My registration number is 57,000 something. Suck on it. Suck on it. I wonder if... Yeah, hold on. Let me check something. This might be interesting. Okay. Let's see if you try this. No, okay. Anyways. Yeah, so that's cool. So I'm going to send him a letter or something. Dear Mr. Starkville lawyer, with the registration number of $67,000, I want to, work for you. The green screen became apparent when it switched to the kitchenette background. Really? Yeah. If you say so. If you say so. Anyways. Yeah. So I don't really have much more to say about this except Karen Yax is going down rapidly. It's not going well. It's not going well, and she doesn't think the rules apply to her. Remember what I said is rule number 1 of litigation? Rule number 1 of litigation, I've said it a couple times. The unwritten rule number 1, don't piss off the judge. Don't piss off the judge. Yeah. Yeah. So, yeah. It wasn't when you had the coffee maker behind you left. It wasn't a coffee maker. So, it doesn't matter. Yeah, there wasn't a coffee maker or whatever it was. Coffee maker is behind the wall in the kitchen. Yeah. Yeah, I guess you can kind of see it. And his chair is green Satouche, and my chair is black. Yeah. Yeah, I'm not sure how to correct for that. I thought I had it pretty well matched up, but yeah, I guess you can kind of see it. Yeah, because you can see the line. Yeah, you can see the line on the underside where it's editing in. There's a green fuzz around your head and arms. See, I don't know what I'm doing when it comes to this stuff. Let's see how I can fix that. Let's see. Let's try to make my video better. Let's see if we can make it any better. Yeah, if I do that, though, it makes the background obvious. It makes it all, yeah, you can see the distortion over on this side. So I have to kick up the color key to get rid of that. And then I wind up with a little bit around my head. Yeah, I'm not sure how to fix that problem. No. No, that definitely didn't work. Lame. Well, it is and is not my real kitchen. It is and is not my real kitchen. It is my real kitchen, but this lens has a different perspective than the lens I took this photo with. Right, so this photo was taken with a different lens, and in my current lens, it you can't see the flag as well on the wall. It's much more because it's kind of tighter, so you can't really see it in the same position. So I'm using the old background because I like it a little bit more. When you used to be able to see the flag in the background and it was clear, and then of course the photo was taken with it being completely clear. So then I went in and artificially blurred it, right, so that the aperture settings on the camera would correspond with what the camera would see at this aperture. And also, it has the advantage of being a little bit more uniform in the color treatment, or uniform as to when I'm filming. So you always would have the same background every time, regardless of time of day. So that way it would be a little bit less problematic. It was the idea. And also, for that matter, people keep telling me to try different backgrounds. And you can see it there with the thing around the edge. You can see it, the lines. Yeah. So anyways, that was the rationale. So I don't know how exactly to fix that. It's not as bad on this side, but on this side you can see it more where it looks artificial. Yeah, I'm not sure how to fix that problem. Get more light on it, maybe. I don't know. I have the key light on. I thought that would do it, and on the overhead light, I thought that would do it, but apparently not. So, all right. You can see it because you're ginger. What kind of green screen software do you use? I'm just using the one in OBS. Yeah, I'm just using the OBS. OBS has a filter where built into OBS where you can chroma key. So I'm just using the built-in one for OBS. Yeah, I'm just using OBS for the green screen. The camera overlay doesn't match the background when you go into document view. I try to make it match. Yeah, I try to make it match. I think it's actually pretty close. Yeah, I tried to make the backgrounds match from both perspectives. So I did think about that. But if you look at where my head is in alignment to the wall, and then you look at this, it's pretty close. Yeah, it's pretty close. And maybe it's a little bit off. Maybe this gap should be a little bit closer, but it's pretty close. So, yeah. It's not the worst you've seen by a wide margin. Yeah, I appreciate that. Also, because people keep saying to use different there's clipping with camera overlay doesn't match the background when you go in Denver. Yeah, I did solve that. Oh yeah, I see. Yeah, because then it just gets replaced completely, where that wouldn't happen in real life. So you got to make sure the document doesn't overcross the thing. Well, actually, if I put the background further up, that would solve that problem. Let's see if I do that. No, well, that kind of works. Where if the thing is, because now you just have the image and it doesn't clip onto it. So maybe that's the way to go. Yeah. If you have RTX graphics card, which I don't, unfortunately, NVIDIA broadcasts background placement using learning from the GPU. Yeah, I don't have that. I was looking at building a new computer, so yeah, I don't know. Charles H. says, I always feel stupid about defamation law. Like, where do you draw the line? Well, okay. We'll just go over what defamation is, what it is, to answer that question. Defamation is a false statement of fact that is communicated to a third party, so not to the person who's being defamed, to somebody else. False statement of fact communicated to a third party and is either done negligently in the case of a non-public person or non-public issue, or with actual malice, and we discovered what that means in the case of a public person, right? And then you need to show damages unless it falls into certain categories which are considered per se. So you don't have to allege damages as part of the cause of action. If it's not in those, you have to allege damages. If not, you don't have to allege damages. So, but you'd have to ultimately get there. You just don't have to allege it as part of the action. So it's a false statement of fact communicated to a third party that is non-privileged, which is pretty rare. So if you're talking to your priest or talking to your attorney, you're covered. So non-privileged, and is done either negligently or recklessly, as the case may be, or knowingly, as the case may be, and some damages. That's basically your defamation case. So there you go. There you go. You could raise the volume of audio. Okay. Yeah, I'm all right. Let me hold on. Is that any better? Is that any better? Is that any better? Yeah. And now I do have this background, which is my actual kitchen. It's just that it would always be the same and it would always be uniform, so it would look more consistent. I thought, at least. So, maybe less with the moving the arms around, because as long as I don't bring my hands up, it's not as obvious. Now, what we could do is use a different background. And here's one I kind of like. So let me know what you think about this background. Yeah, I don't know. Yeah, I'm not so sure about that one. I have to readjust it too. That's kind of cool. That's kind of cool. No? You're not digging it? Yeah, you're not digging it? This cleaner background, too white? Yeah, probably is. Probably is. There you go. The kitchen one looks like you're still in a halfway house. Like you're still in law school couch surfing. This one? This one looks like I'm in a halfway house? Like I'm still in law school couch surfing? What? What? So would defamation would exist if a mandatory reference had lied on your security clearance? Yes. That would be communication to another. And also, it might also be criminal as well. I don't like the kitchen one. That's just my kitchen. You might be able to do a darker background to hide it since the green outline is a darker color. This is just my kitchen, man. This is where you think that this is like you think it's a halfway house? It has an affordability appearance to it? Maybe I like it because it's kind of minimalistic and simple. It looks like a studio apartment. You guys are killing me. I'm getting hate on the apartment. This is the first time, incidentally, in any of my chats. This is the first time in any of my chats that I've gotten hate on the apartment. So I'm just saying, man. Okay, Yeah, dude, he lives by himself. How much space do you need? Yeah, it's a 1-bedroom apartment, incidentally. It's like 800 square feet, or maybe it's, something like that. I think it's just over 800 square feet. I'd have to double check. But, it's a 1-bedroom apartment. This is my living room and kitchen. And then over that way is my bedroom and my bathroom and my closet and stuff. And, Yeah, I it's kind of minimalistic. I kind of like it being, clean and just minimalistic. So, I kind of like it that way right now. So, yeah, looks very homey. I mean, it's simple, but I like it. You should probably move so that will appear more fabulous to viewers with extra flair. You want me to move? You want me to move so that my apartment looks like flashier? I don't know, man. Yeah, my apartment looks fine. It's a bachelor apartment. I mean, okay. I tried turning off the lights in the kitchen and dining room and just use ambient lighting if you take the picture again. Okay. I took a couple different ones, and I don't remember if the light was on in this one or not. I don't think the light was on, actually, when this photograph was taken. This was just taken in the day. So I think that's all natural light, actually. Rack up the Rakita-esque super chat so you can evolve. Hey guys, I am not beyond the Rakita level super chats. If you guys want to give me the Rakita level super chats, I am totally on board. Yeah. So, I mean, I'm happy. It's a relatively clean, simple apartment. But, it's kind of how I like it. And I've got a couch over here. She can't see. And I got a little sitting chair over there for reading books that you can't see. And then, I got, my storage cubbies all up in there for the kitchen. And, my kitchen, Texas flag. Yeah. I think it's nice. But maybe a woman in my life will disagree and want to make it look different, which is perfectly fine. So we'll see. I think you have to cover something anime related, then a bunch of pay pigs will flock to your channel. That is its downsides, though. So do some anime law. And if I can find some, that might be fun. Yeah. If you want to be flashy, just steal a pic of a Malibu mansion. I guess I could do that, too. Rackets had a lot of history and lead up to the Vic stuff. He sure does, yeah. He gets amazing amounts of super chats. I think he's beating us all on super chats in every possible dimension. So whatever he's doing something right when it comes to super chats. He's blowing it out of the water. He gave me a $100 super chat the other day for my 1,000th video upload. That was very nice of him. So I appreciate that. $5 from Ricardo Ospina. Internet is down, but handing some money since you're my only entertainment. Well, Ricardo, as it happens, I've got 1,000 videos on my channel for you to choose from. So I've got a lot of entertainment. So should be able to keep you busy. You did you send me the what is it, the Omega Universe case, Phoebes? Did you send me Omega Universe? Do you want me to get into that? Isn't that kind of old at this point, the Omega Universe? I guess, yeah. Why not get a nice law library background? I've looked, but all the backgrounds I've seen are kind of, they don't look real. This background looks real because it is real, right? It's actually where I live. It's just was taken with a slightly different lens, but it looks like a place I would actually live. And the only ones with the background just look too fake to my mind. I want something that looks real. And this is real, so, yeah. Yeah, the Omega Universe. Yeah, we went through options on a prior law stream. We went through options on prior law streams. We went through a whole bunch of options, and no one liked any of the law library ones that we found. It's really, really hard to actually find a background that works. It's really, real hard. The other day, I still look every time. I was looking on Shutterstock recently for backgrounds, and there was some colored paints that were kind of textured that was kind of interesting, but can't find anything that looks like it would actually be sitting there. This looks like I actually be sitting there because at the time this photograph was taken, it was taken with a lens and it was actually where I'm sitting, right? So this is my apartment. So it looks pretty authentic, yeah. You do it so you don't have to clean. My apartment's very clean. Omegaverse. Is slander the same thing as defamation? Slander is a subcategory of defamation. Yeah, slander is a subcategory. So in defamation includes slander and libel. Yeah. So those are examples of defamation. Yeah. Legal sucks. Yeah, that too. If defamation most common in business or personal cases, it's more common. Yeah. Kim says they like the background. I appreciate that. Thank you, Kim. It is where I live. One UL, two Viva Fry, dead last is Legal Eagle. Yeah, Legal Eagle is more than a little annoying. This is a secret CIA Black Ops site. I don't know about that. Anyways, I guess I'm going to sign off because that's really all. It was disappointing because I was looking forward to a longer discussion, and the answer was 3 pages, and it wasn't very good. And they got the standards wrong, and they don't understand what malice means. So that's great. And yeah, the attorney's going to eat them alive. I'm going to eat them alive. So it's not going well for the critical case. So all the people who said, "Oh, she has receipts, she has a document, she's definitely doing okay," I was like, well, I hope for her sake she does. Not looking real good here for critical K right about now. So given where we're sitting right now, I have to give this about a 98% chance to be won by the plaintiff. It's going super poor. So at this exact moment, it's about 98% for the plaintiff to win. Maybe 99. So, hey, those odds could change. Those odds could change in the future, right? So I'm not saying that's a static 99, but, given what we have right now, I'd say the odds of the plaintiff winning are about 99%. So, yeah, it's not going well. So, yeah. Make sure you turn on notifications for future streams. I thought they were on. I thought notifications were on. Okay. Yeah. Has any pro se ever not been a trash fire? It sometimes happens. Yeah, sometimes happens. Yeah, occasionally. But this is not one of those times. I'm going to sign off for now. If you've enjoyed this legal education and green screen discussion content, please remember to like the video. If you're not already subscribed, please subscribe. And did you know for 99 cents you can become a member? It's true. If you hit the like button, you can give me 99 cents. And for your 99 cents, I will like you more. So that's always a plus. Until later, I hope you're well. Cheers. And goodbye.